I'd like to welcome you to the King's Academy. We're so glad that you could be here for the O'Keefe Pre-Law Studies Program's lecture series. We're in for a real treat today. I got to meet and talk to Scott last night, and he is just an excellent speaker and a great litigator, and he's going to give us some great tips about the Fifth Amendment today, Eminent Domain, and the story of the Little Pink House. So we're in for a real treat today. I want to welcome a number of people that we have here today. We have some members of King's Board of Governors. We also have members of the O'Keefe Pre-Law Advisory Council. Members of the Judiciary are here today. Representatives from the Palm Beach County Zoning Commission. Guests from the South Florida Water Management District. Guests from the Florida Department of Transportation, and many other local, legal, and business community members. And I also want to welcome, we have about 150 students of the King's Academy here today. We have many pre-law studies students. We also have AP American History and American Government students as well. So I'm very glad that you guys can be here today. As Americans, we are so blessed to live in a republic that's governed by a great constitution. And here at the King's Academy, we are committed to teaching our students regarding the rights and privileges that this great document provides them. And so today we will discuss property rights. That is an issue that's near and dear to my heart. I spent almost 20 years in commercial property development before I came to the King's Academy. But in light of what we're talking about today, I want to make it clear we never took any land by eminent domain. And we always bought our land in the free and open markets, so we got our land the right way. Property rights, if you look at them, are really a fundamental human concern going nearly all the way back in human history. In Leviticus, we read that God himself was concerned with property rights and property ownership. He told the people that all the land was his, but then he divided the land up among the children of Israel, among the tribes of Israel. And in Joshua chapter 21, verse 43, it says that the Lord gave Israel all the land, and they possessed it, and they lived in it. And God divided the promised land among the tribes of Israel. And then he even established a year of Jubilee, where every 50 years the land would be returned to its rightful owners, which were the families that originally owned that land. So it seems that God wanted to establish a just and fair system of property ownership, even back in biblical times. So how appropriate it is today that at the King's Academy of Christian School, we are going to study property rights. And we're going to particularly study the Fifth Amendment's assertion that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So if you would, we're going to pray, and then I'm going to turn the program over to one of our gifted law students, Tyler Chinlen, who will open our program with the Pledge of Allegiance. So would you pray with me, please? Father, I thank you that you are concerned with every aspect of our lives, that you even look at the property that we own. Father, I thank you for the King's Academy and how you've given us many years here on this campus and others, and you've allowed us to become such a strong Christian school. And I thank you that you've blessed us with the O'Keefe Pre-Law Studies program. Father, I pray that all of our students here would work to the best of their abilities and that they would learn much today. Thank you that we are Americans that are given rights by the Constitution. Father, I pray that we would continue to defend those. I thank you for freedom of religion in this country, that we can worship Jesus Christ without fear of repercussions. Father, be with us today as we study this case and as we answer questions about eminent domain. I pray that you would be with us and guide us. In Jesus' name, amen.
Pledge allegiance to the American flag. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good afternoon. As many of you are aware, the O'Keefe Pre-Law Studies program is growing by leaps and bounds. We're encouraged by the growth of our program as we get to share with our students principles of law and our legal system, including constitutional principles, with future lawyers, policymakers, and informed citizens. Through the blessings of generous donors, and in particular the Esther B. O'Keefe Foundation, we are pleased to launch the O'Keefe Pre-Law Speaker Series. This series allows us to bring high-caliber speakers from the local to the national level to address students on current legal issues and constitutional concerns. I'm confident today that our kickoff will set the bar high for what is to come. What excites me the most about our speaker series is that this type of experience makes the Constitution accessible to our students. Hearing Mrs. Kelo's story today is a real-life learning experience that can impact generations to come. And for those of our students studying the art of advocacy, we can provide living examples of how powerful advocacy can effectuate positive change. Our goal with today's first topic in the series is for students and distinguished guests to gain a greater understanding of the protections of the Fifth Amendment, as well as an understanding as how courts have interpreted the Takings Clause in recent years. Thank you and enjoy today's presentation.
Good afternoon, everyone. Let me extend my warm welcome to all of you also. Students, we're so proud of your incredible work that you do each and every day in and outside of the classroom. And it is moments like these where we get to be challenged in what we've learned in the classroom, and to hear how it actually worked out in the real world is definitely worthy of your attention. And so we are so grateful for Mr. Bullock, who has been a friend of our program from the early days. He actually came early in the program and spent the day with us talking through how the Institute for Justice could actually be of assistance to our program. So Scott Bullock joined the Institute for Justice in its founding in 1991. And in January of 2016, he became its second president and general counsel. The Institute for Justice pursues strategic public interest litigation that combines courtroom advocacy with media relations, activism, and strategic research to secure constitutional protection for individual rights. Before becoming president, Mr. Bullock served as a senior attorney and litigated a wide variety of constitutional challenges in federal and state courts, including some of IJ's most iconic cases. Of course, today we will hear about one of those important Supreme Court cases that ultimately has been debated since its decision. His articles and views on constitutional litigation have appeared in a wide variety of media forms. He has published articles in the New York Times and the Wall Street Journal, and he has appeared on 60 Minutes, ABC Nightly News, and National Public Radio. Mr. Bullock is a graduate of the University of Pittsburgh's Law School, and he also has an undergraduate degree in economics and philosophy from Grove City College. Would you welcome with me today Mr. Scott Bullock?
Well, thank you so much. It's such a pleasure to be with you today, to get out of Washington, D.C. For a little bit, enjoying you here in the warmth of South Florida. My only regret about today is that Susette Kelo, unfortunately, is not going to be able to join us for the program. The cold weather and snow that's moving into Connecticut, in fact, is keeping her there, and she is now not only a full-time nurse, but is teaching nursing, and she had to be there for a class, so she can't join us, but thankfully you're going to hear about her story and at least see Catherine Keener, a nominee for the Academy Award 2 times, play Susette Kelo in the movie Little Pink House. So look forward to seeing that movie and hearing your questions about this vital constitutional issue. Before we show some of the clips of that, I thought I would talk just a little bit about the work of the Institute for Justice. The Institute for Justice, if you just kind of want a bottom line answer as to what we do, is that we are in the business of suing government officials that violate the Constitution. And business is good. It's good at the federal level, it's good at state levels, and it's good at the local level. And it is this eternal struggle that exists within our American system of people that are put in positions of power. And the founders were recognized that folks did have to exercise authority and exercise power, but they were very aware of abuses of that power. So they designed a system that, to the greatest extent possible, tried to rein in those abuses and tried to disperse that power throughout different branches of government, and established a constitution that served two purposes. One was to limit government power by listing the powers that government has, and then also by having a Bill of Rights that recognized essential individual liberties that were guaranteed to all Americans. And through a series of decisions, that wasn't true initially at the founding, through a series of decisions and amendments to the Constitution, it was made a document so that all Americans are supposed to be protected in these essential rights. And so what we do at IJ is we sue to defend those rights. Because the Constitution, every generation needs a defender. It needs somebody to stand up in order to put those words that were written now over 2 centuries ago into life. Because if you don't have that, then the Constitution is just an old piece of parchment that you can go visit at the National Archives that was written a long time ago. It might not have any modern day meaning. But every generation, it is essential to have advocates that will defend the Constitution and to have clients like Susette Kelo, normal citizens that never asked for this type of battle, were just trying to live their lives and raise their family and try to better themselves, but were called upon to stand up for their rights. And so that's one of the things that we are so fortunate to be able to do, is to defend folks like Susette Kelo in defending her constitutional rights. And the goal of the work that we do at IJ and other public interest organizations do is to establish a precedent that will not only affect and vindicate the rights of the people that we represent, but will hopefully vindicate the rights of everyone. So Susette and her neighbors and so many other people that we've been representing for so many years are really kind of stand-ins for all of us, because they are giving life to these words and promises and guarantees in the Constitution. So that is our goal, is to both win for our clients, but also to establish this broader precedent that will protect all Americans for it. So that's a little bit different than what people do in kind of the just regular practice of law, where you're just representing clients and trying to vindicate their rights. We're doing that, but we also have this larger goal of defending the Constitution and making sure that these rights are protected. Another thing that's a little bit different than the work that we do than kind of the normal practice of law is that we're not just in the courts of law. We are representing folks in a wide variety of different forums. We're in the media talking about our cases. We're in the grassroots community and engaging with folks and doing activism in order to make people aware of what is happening. We're doing research that shows why this isn't just a problem for Susette Kelo, but for a whole swath of Americans across the country who are facing this. And so we're using all the mechanisms of public interest law in order to try to raise these issues up to national consciousness. And you'll see in this movement, we can talk a little bit about it, as to why that is so important to do, why we're not just going into court and advocating for our clients. We are using these other tactics of what we call public interest law in order to advance these ideas. So we typically litigate in 4 areas that has been our specialty. Educational choice, the ability of folks to direct and control the upbringing and education of their kids. So we're very active in the push for greater school choice in the form of vouchers and education savings accounts and tuition tax credits and the like, in order to free up parents and families to make the best choices for their family's needs. So we're very involved in that. We're also involved in economic liberty cases, the ability of folks to start a business in order to advance their own well-being or the right to work. So we represent a lot of upstart entrepreneurs that have a great idea, but are being met with unreasonable government regulation. We're also very involved in the fight for free speech, the ability to speak and to speak your mind about important political and commercial matters. And then finally, we're involved in the protection of private property rights, which is the focus of our movie and our discussion here today. We have a wide variety of issues and cases that we deal with. In addition to eminent domain, we're very active in the fight against civil forfeiture, which some of you might have heard of, which is the crazy power that government has to take your property regardless of whether you are guilty or innocent of any wrongdoing. If you don't know about it, check it out on our website. It's probably a little bit beyond the discussion we have here, but it's another example of what happens when people's property rights are not protected. So if you think about those four freedoms that we try to vindicate, it's kind of the essentials of the American dream. That's what most people want to do. That's why so many people try to come to America, is to pursue an occupation, to raise their kids as they see fit, to speak their mind freely about political or commercial matters, and to own and to use private property. And so those are things why they are so important, but unfortunately they are underprotected by courts in so many parts of the country. So we are there seeking to vindicate these essential American freedoms. So one of our hallmarks of our private property work has been the fight against eminent domain abuse. Let me just turn and quickly talk about that, and then we'll start showing some of the clips of the movie. Eminent domain, as a lot of you have studied, is the power of government to take away your home, your business, your land. It is one of the most awesome powers the government has at its disposal. Apart from putting you in jail, to take away your home, to take away where you're trying to earn a living, is a really, really serious power. It was called at one time the despotic power of government. And so the founders were so concerned about potential abuses of that power, they sought to limit it through the takings clause of the Constitution. Now they recognized that sometimes eminent domain could be legitimately used and could be proper, but they put two important limitations on it. The government was going to take your property, they had to pay you for it. They just couldn't come in and take your property, throw you off your land, and not give you any sort of compensation. So that's why the Fifth Amendment says you are entitled to just compensation. There's a whole debate about what just compensation means. There's a lot of litigation about that and how do you determine what is just, but the government has to pay you if they take your property. But the more important limitation, and the one that's the most fundamental, is that the government can only take your property, it says in the Constitution, for a public use. And most people know what that means, and what the founders had in mind, or what most people would think of as public use. Well, that's a road. That's a military base. That's a public building, a new courthouse for it. Those are things that are owned by the public, or that everybody has the right to use, like the roadways or the railroads that were built in the 19th century. But over a series of decades, into the 20th century, government started to try to expand the use of eminent domain to include things like private development projects. And they said, well, that's sort of, we're taking land from one private owner and handing it over to another private owner, but could we say that, yes, and that's not really a public use, but how about we say the public will benefit from this, won't they? They'll get more tax revenue, and we'll have more jobs and greater economic development for it. So you see after a number of decades that this power was expanded, and unfortunately over the course of many decades, courts started signing off on this expansion of power. And so when we started doing these cases, we said this is wrong. This is just fundamentally wrong. And most people are against this, and it's not in keeping with the text of the Constitution that says public use. So we did a whole series of cases, and the public interest campaign that I mentioned be seeing a little bit of here, to try to change the law and to ultimately change the world about one of these most serious powers that the government had. So that led us to the fight in New London, Connecticut, where the city and a private development corporation sought land not for a road or a reservoir or a dam or a public building, but because the city was down on its luck and they wanted to attract new private businesses there and to play off of what they saw as their economic savior coming into town, the pharmaceutical giant Pfizer that moved in next door to the Fort Trumbull neighborhood. And we said, this is not a legitimate use of eminent domain. This is for not public use, but private use. And people like Susette and people that lived in this neighborhood didn't want to go. They didn't want to sell. These homes in this neighborhood meant everything to them. So that's a little bit of the backstory. It sets up, I think, the movie quite well. I think we're going to show clips of it, then I'm going to come up and talk a little bit about what we saw and give a little bit of some of the backstory of it, and then leave time for your questions at the end. Thank you. A little bit of an introduction to the players that were at issue in the Kelo case, and it was a great introduction to Susette. And as I said, unfortunately, she wasn't able to join us. But let me just tell you a little bit about her backstory, and you saw how affected she was when she saw that piece of property. Susette grew up in poverty in rural Maine. She was a teenage mom. She was in a failing marriage. She had raised 5 sons before she was 40 years old, and she decided she was going to have a new start on life. And so she went out on her own, started as an EMT, and got some training for that, and that's how when she first saw the little pink house, it wasn't little pink when she first saw it, it was in pretty bad shape. That was the first piece of property she ever owned in her entire life. Never owned a piece of property before. And so when she saw that, this was not just something, a place where she could kind of rest her feet. It was so meaningful to her. It was an extension of who she was and what she wanted to be. And that's why she poured her heart and her labor into it, painted it her favorite color, and really made it her own little sanctuary. Up the road from Susette was the Dairy family in New London. Unlike Susette, that had never been a homeowner until she was 40, the Dairy family had lived in the Fort Trumbull neighborhood for over 100 years. Mrs. Dairy was born in the house that she had lived in 1918, had never lived anywhere else. She and her husband lived there, her son and his family lived next door. And these were true family properties where generations had lived. And that's why those homes meant so much to them. And that's really important element to keep in mind, is that property rights are not just about how much a property is worth monetarily. For so many people, it means so much to them personally. And that's why they fight so hard to hold on to it, and why the government should have a really, really strong justification for taking it away from them. Not to hand over from one private owner like Susette and the Dairy family and just give it to another private party like the developers that wanted to move next door to the new Pfizer facility. And that's that was the clash that was going on in New London. And you also saw here too is that this was a project that was not really driven by the market. This was a lot of politics that were involved in this, where the governor wanted to look good and use his influence in a city where he didn't have a lot of influence. So what levers did politicians have? Sometimes they had money. And so that gains the support of a lot of local officials. So you had the local officials then team up with the governor to get behind this project, and they was eventually over $80 million in taxpayer money in order to try to do this project. So the other thing that you see in this movie was a great depiction of how deals are really made too. Yes, political figures will always kind of say, yes, we're doing this for the community, and there may be a part of that they sincerely thought this was better for the community and they were going to benefit from the jobs and supposed economic development that was going to take place, but there's a lot of other things that are happening behind the scenes and what motivates government officials and private parties in order to make these decisions. So that was a little bit of a depiction of those dynamics that are at work. Go to the next one. Well, you see a little bit at the end there, the justifications that Charlotte Wells, who was the president of the local college in New London, that's not her real name, but she was using in order to try to justify this. Yes, we might be taking it from one private owner to another private owner, but the public is going to benefit from this. There's going to be more jobs and more tax revenues. And isn't that enough under the Constitution, even though the text says public use? And so that is the mentality that they had, and that's what ultimately you'll see that was the thrust of their legal arguments then too. I thought these clips also really demonstrated too what Susette Kelo was saying as she stood up there and started talking is that one of the reasons why they wanted to have this property is because it was a really nice waterfront piece of property that happened to be an older working class neighborhood. And they thought, my God, we could bring in a lot higher and better uses for people with higher income into this waterfront property. And waterfront property, as everybody knows, especially in Florida, is quite valuable. As a matter of fact, when they were making this movie and they were trying to find properties and neighborhoods that kind of matching and not shoot, obviously, in New London, it was hard to find a neighborhood of basically working class and smaller homes next to the water, because most of those neighborhoods are for wealthier folks. And so that is what was driving it. One of the things that people liked about this community so much is even though it was poor, there was a sewage treatment plant next to it that somehow miraculously got cleaned up as soon as Pfizer wanted to move into the neighborhood. They wanted to hold on to this property because of the community commitments and connections they made there, and also because it had these beautiful views too. The other thing that I think these clips really showed, and you'll see this even more dramatic, I think, in some of the other clips, is the pressure that people like Susette and oftentimes even elderly folks faced. The NLDC and the city were relentless in going after them, badgering them, real estate agents showing up at their homes, talking about if you sell now, you'll get a little bit more money, you better sell, or we might turn to alternatives. And that is why eminent domain is so different. You know, if you want to buy somebody's property, you can try to reach a price, a mutual accommodation, and if you can, great. If not, you've got to live with it. But with eminent domain, you don't have to live with it. You have the power of the government behind you that can force people off of their land. So these property owners and homeowners endured this fight for over 6 years of constantly living under this threat, and it took a big toll on the folks that fought this. Some people, before the lawsuit began, they didn't want to sell, but they felt like they had no choice. But 7 homeowners stood together to fight this, and all hung together from the very beginning of this case up to over 5 years later, from just the court battle alone. They all hung together and stood up to this, and they were just working class citizens that were willing to make a stand. And that's why I think their story is so heroic, and I'm so glad that it was told first in a book and then was being told in this movie. So let's do the other clips. Well, the actor playing me had much better luck at facial hair than I ever did. So that's why it says at the beginning, based on a true story. But this is our involvement in the case, and this is an issue that we had been litigating for a number of years at that point, we were taking on a whole series of cases to try to transform the law. And when I came to New London, it was had exactly what we were looking for in a public interest case. It framed the issue just the way we were wanting it. They were not claiming this was for public use. They weren't even claiming that the neighborhood was blighted, which is another justification used in previous decades. They just said, we can make better use of this property. We can get more tax revenue, more jobs. They said that alone was a justification for the use of eminent domain. It had that. It also had a group of people that were willing to stand up and defend their homes. And so that's one thing that you're always looking for when you do a public interest case, are people that are willing to make that stand, who are willing to stick through with it, and who are willing to go public with their fight too. And you see that in that clips and others. And Susette, this was not her life. This wasn't something she was particularly comfortable in doing, something that she never sought out, never sought publicity for herself. But she, after talking to us and realizing the importance of it, stood up, got out of her comfort zone, and was willing to make these public statements about what was happening to her, which is absolutely essential. The other thing that's essential for a good public interest case is just outrageous actions on the part of the government. And you saw that over and over again in this case. You saw a little bit of that with the demolition. And this was what the NLDC did. Once they acquired a home, some people, as I said, volunteered to, either they voluntarily sold or they sold under a lot of pressure, and they felt like they didn't really have much of a choice, and they said, I'm going to get the best that I can and get out of here before eminent domain comes along with it. So what the NLDC did, as soon as they got a home, they demolished. They didn't have to do that. They could have let the people stay in there, kept them standing, maybe even rented them out while this case was going on or while the project was proceeding. They tore it down. And these homes are in Fort Trumbull, they kind of classic New England homes, are even a lot closer than what the neighborhood in the movie was depicted. And so it was a not so subtle message to the other people that was there, is that your home is next. And as that scene plays out, and what happened in real life is, as they were tearing down the house of the right next door to Susette Kelo, construction debris and glass were falling on her home, and it was just like living in a war zone. And these people had to endure this day after day and week after week as this case progressed. As you saw during the trial, too, they then said, we're going to charge you rent for your homes. Because a nice little procedure of eminent domain in a lot of states is that once the eminent domain action is filed, title to the property passes to the condemning authority. So then you are a tenant in the home that you might have owned your entire life. The Dairy families that lived there for over 100 years started being charged rent for properties that were mortgage-free for over 50 years. Another outrage about this. And yes, because the president of Connecticut College has a degree in French literature, she did explain to us what French logic was during the course of the trial. And I did have that look on my face, and I think the judge even had a more inexplicable look on his face during the course of it. So let's continue on. Before we open it up for questions, I'll just talk a little bit about what you saw there. They packed a lot of the legal history into the end of the movie, and we had a split decision in the trial court where some of the homeowners won, other ones did not. Everybody decided that they were all going to take it up on appeal. The Connecticut Supreme Court, in a 4-3 decision, ruled against us, but they teed it up perfectly for us to take it up to the U.S. Supreme Court. And it was, of course, a huge uphill battle to get the court to take it up. They take less than 1% of the cases that come to them, so the odds are not good for it, but they did take it up, and then it led to the Kelo decision where the court, by a 5-4 majority, ruled against the homeowners. But as we saw if you remember in my beginning of my top when I mentioned that in public interest law, you're not just litigating in the courts of law. You're doing this wider public education campaign and really raising national consciousness about this issue because of this very reason, is that even if you lose in court, like we did in the Kelo case, enormous change can still come about. And that's because people know about the issue and they could not believe that the court would sign off on this. So we had the greatest backlash against any Supreme Court decision in modern history. It led to over 40 states changing their laws to better protect private property owners. Dozens of projects were defeated in the wake of the Kelo decision. So a lot of good came out of this incredibly misguided decision. Our ultimate goal, of course, is to get the issue back before the Supreme Court, to get them to reach the right result in this case. And as you saw at the end of this, of what's happening in New London, is that absolutely nothing has happened in this area. So they spent over $80 million in taxpayer money, waged this court battle, insisted that everybody have to clear out, and nothing was ever built. There's a nice community of feral cats that live in the neighborhood now. They've set up home there, but all the homes are gone. No new development has come in. And then the Pfizer plant that had moved in right next door to the New London neighborhood, and this was supposed to complement the Pfizer facility, they moved out as soon as their tax breaks ran out. And this is what oftentimes happens in Eminent Domain, is they cut deals with companies, and they say, well, you know, if you move here, you don't have to pay taxes for 10 years. And they say, great, sounds good to us. They opened, stayed for 10 years. As soon as they were supposed to pay taxes, they said, you know what? Our fortunes have changed a little bit. Our priorities aren't in New London. We're going to move on from it. So that's really the sad legacy of not only this project, but so many of these projects over the course of many decades either failed to live up to expectations. All these great promises were made, all it's going to do all these great things, and then it said it never lived up to expectations. Or like in New London and so many other neighborhoods and inner city communities, nothing was created and they were absolute disasters. So that is hopefully a great reminder to political figures and private business interests that want to go down this path again. You shouldn't do it. It's a power that should be limited to true public uses, and you might end up like New London did, which is a lot of pain for the people that live there, a lot of money spent, and absolutely nothing to show for it. So let me stop. There's a microphone around for some questions, and let's hear what you have to say.
Okay, at this time, I'm going to open it up for any questions from our guests or students. If you could just put up your hand, I'll come to you, and we can ask Mr. Bullock anything that we would like to ask about the case or its ramifications.
Hi, my name is Julia Lubitz, and I was just wondering, what was probably the hardest part of building your Supreme Court case or your argument for your appeal?
It's a great question. So one of the most challenging things was the court had, over the course of the past basically 40 to 50 years, had issued a series of decisions that gave this broad interpretation to the public use requirement. We read it very broadly, the case back in the 1950s and the 1980s. And the Supreme Court doesn't like to overturn its previous decisions. Sometimes they do that, but they're very reluctant to do that. There's this legal doctrine of stare decisis, which means that a fancy Latin phrase for there have to be really good reasons to overturn it. So we had to address those two cases. And we said if you want to overturn those, you're more than welcome to do so. But you have to distinguish those cases. And you have to say, listen, yes, those were broad, but they're not as broad as what the city is doing in this instance. Because here, they really are saying that as long as we can think of a more productive use for the property, then that's a justification for the use of eminent domain. Because all they said was, we project that this will produce millions of, I think the estimate was $4 to $6 million in new tax revenue, and anywhere from 500 to 1,200 jobs.
And they said, that's the projection. Well, homes don't produce any jobs and limited tax revenue for it. So as long as you can conceive of a more productive use, then eminent domain can be justified. And that really is a vision of eminent domain without any sort of real limits. And as we saw here too, is if plans fall through and the project's never built, oops, you have no recourse because the property's already in other hands. So we said, listen, those cases did not at least address that, and the court has never gone so far as to sign off on that. And that was the theme of the case. And that's why you saw when I was presenting the argument, I started off by saying no church, home, or corner store would produce more tax revenue if it were a Costco or a shopping mall and that sort of project. And that was our fundamental theme. And if you saw Justice O'Connor, the person that was playing Justice O'Connor, picked right up on that, and she said, you need to say, so if you had a Motel 6, and somebody came in and said, well, let's have a Ritz-Carlton here. Would that justify the use of eminent domain? They said, yeah, that would. And that was the real heart of this, the real danger of it. That line actually made Justice O'Connor's dissenting opinion in the case, because she was so disturbed by that. So that was kind of the biggest challenge, was addressing those previous decisions and saying, well, you don't have to overturn these, but you at least have to draw some outer limit on this topic.
Other questions?
Hi, my name is Ariana Medina, and so I was wondering, after the case, were the people who still own homes, were they given recompense to buy new homes, or were they not given any money?
Yeah, so they were treated much better than they were going to be treated, and they were given better compensation than certainly what was originally offered to them. But they ultimately didn't want to leave. They would have been happy to say, I'm not interested in money. And as the case progressed, they were offered more money and probably would have been. But they said, listen, I don't want to do that. So they all were better compensated than they otherwise would have been. But it's another kind of injustice with eminent domain, is that just compensation, I alluded to that a little earlier, it's a long, complicated story, but when you get compensation under eminent domain, you get just the fair market value of the property. So it's like what the appraised value of the property would be as the single family home. And usually, people might be interested in selling their property for that amount, but most people, if they're going to sell, it's going to have to be at a premium for it. Under eminent domain, you don't have to do that. You can just pay the appraised value of the property. The other thing that happens too in eminent domain is that once the land is taken, it's typically rezoned, and then it goes commercial, and then the value of the property skyrockets. But the value of that goes to the new owners of the property that were given the property, not the previous owners to it. So it's another thing where, it's another injustice where you don't have to do when you're privately negotiating with people, where people say, hey, listen, I don't really want to move. If you pay me enough that I can buy a comparable house in a similar neighborhood, like maybe near the water, maybe we could talk about that. Eminent domain, kind of all the incentives for parties to do that and to try to reach some sort of compromise go out the window, because they know at the end of the day they're going to be able to take it for them. All the property owners left New London. They all kind of still live in the same neighborhood, but it was a city that was not interested in keeping them, which is just amazing, because it's a city that has gone through some serious trouble, and these were people that truly wanted to stay. And you'd think the city would embrace them and say, great, these are people that are totally committed to this city, regardless of all the problems and challenges we have. But they said, no, we want you out. And so now none of them live in New London. But ultimately, they would have preferred to just stay in the neighborhood.
And perhaps you could tell us about what happened to Mrs. Kelo's house eventually.
Yeah, that's a great point too. She was, again, wanted to stay where she was. They insisted on everybody moving. We were out of legal recourse at that point. But we negotiated to make sure they received much fairer compensation for their properties, worked with the governor's office on that. And part of the arrangement too was that Susette Kelo's home was taken apart
and a historic preservationist who would work closely with the property owners, was always on their side. He said, I'll take the house and I'll rebuild it on a piece of land that I have in downtown New London, which is what he did. So they took it apart slat by slat, and he rebuilt it. And it's actually quite a small house, a little just tiny Victorian 2-bedroom home. He added a little bit to the back of it and onto the side of it. A great builder and a great guy named Abner Gregory. And kept the footprint of the home, kept it pink. And now if you're ever in New London, you can visit. It's called the Kelo House. And he lives there. And it has a marker out front that talks about the case, and there's a big post in front of it that says, "Not for sale." And so that was a nice legacy that showed, anybody that's visiting the city what the people have done. And that's something that, even though they were very upset about what happened to them, they could take a lot of comfort in the fact that this fight was not in vain. That because of their stand, laws changed in so many different places, and so many more people are aware of this. So that they were true heroes that stood up to this and have a proud legacy, even if they were not able to keep the homes that they valued so much.
Other questions? Okay, let me come around this side.
Hi, my name is William. I want to ask, do you see a need in amending the Constitution since the public use is not very well defined?
Well, I don't. I think it's one of these issues that it is pretty well defined. It's more well defined than a lot of provisions in the Constitution. And actually, and Justice Thomas, in his dissenting opinion in the case, goes through and does a really nice historical analysis of what does public use mean? What did they have in mind? And what's the history of this before it was starting to be expanded in these cases I mentioned earlier, starting in the 1950s? And he said, this public use, and obviously it's public ownership, that the public owns something. But it's even a little bit broader than that. If everybody has the right to use something, like a utility line, that's why you can oftentimes use eminent domain for a building like an electric transmission line or a railroad, because everybody has the right to use the electric, has the right to use the railroad with it. So that could be legitimate uses of eminent domain. So if they really stuck to the text as it's written and as it was historically defined, I think that would be enough. The problem is that they kind of expanded it beyond that and said, well, we're going to read public use to mean public benefits in the form of higher taxes and more jobs. But it has, there's a lot of provisions in the Constitution that are vague. What's an unreasonable search and seizure? What does equal protection mean? So these things that you can debate, public use has a pretty good definition. So we're hoping that they'll get back to what its historical role was and limit its use to true public uses.
Okay, there were some questions up here.
Why were you chosen to work on the case?
Well, it was something that I was very passionate about, and my colleague Dana, you saw in there, a woman who played Dana Berliner, is another attorney at IJ. She's now our senior vice president, brilliant lawyer. And she and I started working on these cases back in the 1990s, and I got really devoted to them, gained a lot of knowledge about it. And so it kind of just happened that we were the people that were working on this. And one of the things we try to do at IJ too is we develop people from an early age to do this type of work. And a lot of people that have been in IJ have been there their whole careers, and they've devoted their careers to pursuing this. And so once you develop that specialty, you typically stick with them. That's what the former president of IJ, Chip, did, and let us continue to do these cases and to argue it. And now we have a whole new generation of folks that are coming up and doing the same thing. We just had one of these forfeiture cases that I mentioned before that you can check out that we're litigating on the property rights front. We just had another case before the Supreme Court on that issue that was just argued in November. One of our attorneys argued that case. It was about the age that I was when I argued that case in my late 30s or so. Did a fantastic job. We're hopeful for a very favorable outcome in that case. It wasn't part of the clips, I think, because you had to cut it, but when I first went in there, there's these funny scenes that actually did happen, and they said, "How old are you?" And I said, how long have you been out of law school? So we're wondering, because usually when you practice constitutional law, people think you should look as old as the Constitution. You know, when we're young, people are at least at first saying, you know, do you know enough about this? But then we became great allies and stuck together throughout all of this.
You spoke on public use and how that's been pretty well defined. How about just compensation? Do you feel like we should revise the Fifth Amendment to better understand what just compensation means?
Yeah, I mean, that's a great point. You know, there have been various proposals with that, and there's been some attempts to give greater compensation to folks, typically through statute, you know, so you might not have to amend the Constitution for that, but just say, listen, we're going to be more clear about what just compensation means, and so you'll get premiums based upon potentially how long you've owned the property. Or, for instance, you get an ownership interest in the new property. You know, if the value of the property goes up, you should be able to take a portion of that new value of the property that's been created from it. So there's some interesting experiments. But I think that's no substitute, though, for limiting the takings to true public uses, because that way you get away from trying to figure out what you do when you give land from one private owner to another private owner, which is private use, not public use. So that's a better course. But there have been some attempts, and even some of the state reforms that have passed in the wake of Kelo have at least upped a bit of the compensation that is value that has been given to property owners.
So could the case of Kelo versus the United States, could that result have justified, in addition to the Constitution, to change the employment of eminent domain?
Yeah, so I mean, the important thing to remember about the Constitution, constitutional provision, is that the Constitution just sets a floor of protection that the court says is entitled, that all people in the country are entitled to. And so, as long as no state falls below that floor, they're free to do as they wish. And so, a lot happened in the wake of Kelo, so a lot of states said, okay, you know, the court has said that there's very limited protection under the Fifth Amendment, but most state constitutions, in fact, almost all of them, have their own provisions in takings clauses in their own state constitution. So they said, well, we're going to read our state constitution to be more meaningful than what the court said the federal constitution is, which is great, and that's to be encouraged, and they're free to do that. And even the majority opinion in the Kelo case written by Justice Stevens said, you know, states are free to protect property owners to a greater extent than what we're going to do in this case. And that's what they did either through state constitutional amendments, state statutes, and as I said, as long as they don't fall below that at a floor of protection, then they're free to do that.
If your case went to the Supreme Court today, do you think it would have a different outcome?
Well, no, it's an interesting question. You know, the court has flipped some members since that time, so I don't know. You know, we're hopeful for that. They're going to take it up. I think one of the things that the court is looking at is what's happening in the states. You know, because a lot of states reacted so quickly to this, even though that never would happen before the Kelo decision, I think the court felt like, well, maybe we'll just let this kind of go for a little bit, see how it develops before we get back involved in this. And you see this over and over again in a lot of Supreme Court decisions, that they issue a decision and then they see how it plays out and see how the law develops and whether it develops in a way that they think is good or bad. And then usually takes years, sometimes decades, before the court gets involved in this again. And I think that's what happened in the Kelo case. This decision in 1984 of an eminent domain case out of Hawaii. It's kind of an odd case because Hawaii was a former monarchy and it had a weird system of land ownership. So the court in this 1984 case gave a very broad reading of the public use clause. And then that oftentimes led to this really aggressive use of eminent domain that you saw like in London and so many other cities. And so then the court said, we have to take a look at this again. You know, we have to get involved in this and see where we are with it. And then, you know, so it took, you know, that was 20 years before they looked at that. Something similar might happen here, but I think given the change in the court, also given the fact that now it's been almost 14 years since the decision, And you're starting to hear cities, after this being alleviated to a great extent in most places, you're starting to see cities and private interests start talking about doing this more and more. So we're staying very aware of that. We're staying vigilant. And so if they start using this again in a more widespread manner, I think the court will say, now's the time for us to come back in and re-examine what we're going to do with Kelo.
How many cases does IJ get per year?
Yeah, that's a good question. Typically, we litigate about anywhere from about 50 to 55 cases that we currently have. I think about 50 or 51 cases right now. Those are at various stages of development. And we look very carefully, and we're very selective about the cases we take on, kind of like the way the Supreme Court only accepts a certain amount of cases, because we're looking for the case that's just right to have the most potential to set precedent too. So we have to carefully look at the legal issue, whether that's framed right, the clients too. We get very selective about the clients that we take, and we want to make sure that these people are willing to make a public stand. And then we do a lot of the other work in addition to being in court, writing op-eds, giving talks, and speaking out about the issue and why it's so important to the broader community. So we do as much as we can. The other thing that's great about IJ and other public interests, so we're a nonprofit law firm, and so people contribute who believe in what we're doing, and therefore we don't have to charge our clients. And so a lot of these battles never would be fought if people had to pay for it. There's no way. You saw that in there because it said, we don't have to pay for it because we don't have any money. And most people, you can't afford out of pocket to pay a lawyer. Now, if you want to sell your property, a lawyer, would be willing to represent you because then they get a certain amount of percentage of what greater compensation they get for you. But if you say, I just want to keep my home, then you're going to have to start paying a private lawyer to do it. So a lot of the cases that we take on would never be fought if people actually had to pay out of pocket for the legal services. So that's great to be able to represent people and fight this and not have to charge them for it. And thankfully, we've been fortunate enough to have a whole group of people, over 8,000 individuals and foundations who are supporting our work.
Did you ever consider not taking the case?
No. After I visited there, it was one of these things where we just knew we had to take it because it had those wonderful elements of public interest law, the issue positioned just right, the clients being so good and so willing to make this stand, even albeit reluctantly at times. And then what the government was doing was just so outrageous. It was so terrible what they were putting these people through. And it was really this attitude of, we have a vision, we want to get this done, and we don't care what happens along the way. Kind of ends justifies the means approach. And that's always really dangerous when anybody or institution has that type of approach. And it's something that's totally contrary to the Constitution. The Constitution doesn't allow an ends justifies the means approach. That's what the Constitution's all about. Yeah, you do development, but you can't steal people's property for it. You can pursue the bad guys, but that doesn't mean you can violate the Fourth Amendment, that you can just break it. The cops can go into anybody's home and search it because they think, well, we think somebody ran off into this neighborhood, and so we're going to try to find him, so we're just going to go into everybody's house and search it. That might be efficient, that might actually catch more of criminals, but the Constitution says you can't do that. The price is too high. The price we pay in our lost liberty would be too high. And so that is what you see in a lot of these eminent domain cases, is that we got to get this done. We have a vision of what's right, and consequences be damned. And that's a really dangerous position for the government to be in. It all the more justifies getting IJ a similar protocol.
We have time for one more good question. Who has a good question?
Is there a vote?
Given the trend of increasing federal government powers the past few years, do you think that we might be moving towards a time where the government might move towards limitless eminent domain as long as they can deem what just compensation is?
Yeah, so it is something that we're very concerned about, is the growth of government power. And it is a danger because the Kelo case has opened up the door to these types of takings, especially at the federal level for it. So people say, what government bodies do you sue? And I say, all of them. Because we sue the federal government, we sue state governments, we sue local governments, because all of them are capable of violating the Constitution. So we stay on top of all of it, and we're going to be there to defend the constitutional rights of any citizen, whether it's in a battle with the feds or state and local governments. And local governments too can be tyrannical. We call it grassroots tyranny, and sometimes more effective than the kind of clumsy, out-of-touch federal government that's kind of far away sometimes and might not know what's happening in a particular area. Here, these were the local powers that be, from the governor on down. And yes, the governor did go to prison, by the way, in Connecticut for it. And you've got to stay vigilant in protecting people's rights.
Excellent questions, and thank you, students. But let's thank Mr. Bullock for studying. We'll have some time during our reception. I'm sure Mr. Bullock will be happy to answer lingering questions. And at this time, I'm going to turn it over to Mrs. Jones, who's going to close out our program.
Thank you, Mr. Bullock, for being here. You really have set the bar high for our speaker series, so I would not be happy to be following you, that is for sure. And please let Mrs. Kelo know that she was missed today, but we are so appreciative that she was willing to not only share her story with us, but to share it with the world. And also know that what you have done today, I believe, is going to impact many students here at the King's Academy. And I can imagine that we will hear about some of these students in the future maybe taking up similar cause or other types of situations and speaking for those that can't speak for themselves. So we really do appreciate it. One of the key things about our law program here that Mrs. Brown has so effectively done, one of the parts is that we really emphasize ethics. And as I was watching the movie and as you were speaking, that's what came to my mind, was the ethics that can be involved in all of the careers that we want our students to have in the future. And I think about that, especially in the law program. We have many other programs. So thank you for that. Thank you for being here today. We are very grateful for all of the other community members that have made it out today to be a part of this first speaker series. And so we are so excited about what's happening here at TKA and grateful for all of you. So thank you. Before I close us out in prayer, just a couple of housekeeping items. We would like to invite all of our guests to a reception that will be located outside of our lobby. And you will be dismissed after the closing prayer. Students, you're going to wait a little bit and I will dismiss you, so you're going to stay seated. And then after our guests have shared the refreshments, then you will be able to participate and partake of the refreshments. So don't fear, you will get something today. So please pray with me. Father, we're so grateful for people that want to change this world, Lord. We are grateful that we have programs like this. We are thankful for our guest speaker, Lord, and for those that came out today to support what we're doing here. Lord, we are so grateful that the most important thing is that we point people towards you. And Lord, there are times that we have to speak for those that can't speak for themselves, just like you did when you died on the cross. Lord, I'm grateful for the students here. I know that you are going to inspire many of them to go out and change the world. We just appreciate all that you've done for us today and the time that we've had together. In your name, amen. Please, guests, you are dismissed.